Getting a law degree is just the first step in the UK legal system. Almost immediately, you are forced to make a hard, practical decision about what kind of lawyer you actually want to be. You have to choose between two completely different career tracks, becoming a solicitor or becoming a barrister. Guessing wrong here carries a high penalty. You risk losing years of specific training and tens of thousands of pounds on courses that simply do not transfer. Making the right call isn't about whether you have an aptitude for the law. It comes down to your personal financial risk tolerance and how you actually want to spend your daily working life. Everyone starts in the exact same place. You either complete a 3-year qualifying law degree or a non-law degree followed by a 1-year graduate diploma in law, known as the GDL. This diagram illustrates exactly where the pipeline breaks in two. From that shared starting point, the educational requirements permanently diverge. On the solicitor side, you must complete the Legal Practice Course, or LPC, and then secure a 2-year training contract working inside a law firm. On the barrister side, you take the Bar Practice Training Course, the BPTC, and then you have to secure a highly competitive 1-year placement shadowing a senior barrister, known as a pupillage. Because the mandatory practice courses and apprenticeships are entirely different, crossing over later is incredibly difficult. You have to commit to your track early. The starkest structural difference between the two roles is your legal employment status. When you secure a training contract on the solicitor track, you are hired as a direct employee of a law firm. That employee status gives you immediate stability. You get a guaranteed monthly salary, pension contributions, paid holidays, and frequently private health insurance. Barristers operate on a completely different model. When you finish your pupillage and join a set of chambers, you operate entirely as a self-employed practitioner. You have zero financial safety net. There is no holiday pay, and your monthly income fluctuates wildly based entirely on your personal reputation and the volume of clients you can bring in. The pay variance at the bar is extreme. While some barristers take home massive incomes, junior criminal barristers can sometimes earn below minimum wage in their early years. The core trade-off is clear. As a barrister, you get pure, uncapped autonomy over your schedule. As a solicitor, you trade some of that independence for a high, secure financial floor. This matrix compares the upfront financial barrier for both paths. City firms will frequently pay your entire LPC tuition cost and provide a maintenance grant for living expenses. The barrister track offers no corporate sponsorship. You must self-fund the £20,000 BPTC with no guaranteed job. The corporate solicitor track functions as sponsored risk. The barrister route forces you to shoulder massive personal debt before your career even begins. Beyond the money, you need to examine the actual daily environment of each role. A solicitor operates essentially as an end-to-end project manager. When a client walks in the door, the solicitor builds the case file and manages the strategy right up until the court stage. The work is highly collaborative but heavily desk-bound. You spend your days proofreading documents, drafting case notes, and attending continuous client meetings. A barrister is a specialist. Their core daily function is providing narrow legal advice and executing physical courtroom advocacy on behalf of the client. Barristers act as the lone wolves of the legal system. Solicitors feed the cases to them, meaning barristers have very limited direct client contact outside of the court. The environmental choice is binary. You are either a collaborative, behind-the-scenes project manager or an isolated, highly specialized courtroom performer. This quadrant chart plots exactly how your risk tolerance aligns with your desired working style. The stability seeker belongs on the solicitor track. This is for people who want guaranteed income, structured team collaboration, and the satisfaction of managing a case from start to finish. Within that quadrant, you can choose high street firms for standard hours and lower pay, or city firms for grueling, late-night hours and extremely high salaries. The independent performer belongs in the barrister quadrant. This fits people who thrive on public speaking, prefer to work alone, and have a high tolerance for financial uncertainty. Neither path is objectively superior. Your success depends entirely on correctly diagnosing your own working style and risk profile. If you are undecided, you need to actively test these paths before committing your own funds to a training course. To test the solicitor track, aggressively apply for vacation schemes and first-year insight days to experience the reality of a corporate firm's culture. To test the barrister track, enter university mooting competitions and apply for mini-pupillages so you can observe advocacy firsthand in your local courts. Getting experience in both is highly strategic. Completing a solicitor scheme gives you hard evidence to use in a pupillage interview to explain exactly why you rejected the firm route. Do not guess your career preference. Gather the empirical data through diverse work experience and protect your future investment.